If you've then messed up on this bit here, you could potentially be owing the landlord a lot of money if they're unsuccessful with their claim. The Deregulation Act, another piece of legislation that is all really very important for possession proceedings. If you get bits of the Deregulation Act wrong, that's how you're going to find that you've got challenges in court. It's getting harder and harder to gain possession in courts. So it is important that your documentation are in order. And don't forget, guys, if you are offering rent guarantee, like I hope all of you are going to go home and do, if you've then messed up on this bit here, you could potentially be owing the landlord a lot of money if they're unsuccessful with their claim. So we know the gas safety, that's been around since 1994. I hope you all know that you need to get a gas safety certificate and issue it to the tenant prior to the start of tenancy and evidence that you've done so. The How to Rent Guide, the correct version. I love DocuSign for this because we send all of the documents on DocuSign. So literally they physically sign the document that we're giving them. So any electronic signature. An EPC that's valid at the time of moving. I've put that because during a tenancy, if an EPC expires, there's no law that states that you have to legally renew the EPC. But there is a law that states you have to have a valid EPC for marketing and you have to have a valid EPC before you move a tenant in. My advice to all landlords is always just renew the EPC. They're so cheap, they last 10 years. You don't want to be the person that ends up in court with a judge that doesn't know the rules and throws it out because you haven't got a valid EPC. So my advice, best practice, always renew the EPCs if you can. And then licenses as well. If you licensable HMO, additional licensing areas and selective licensed, you have to make sure the application is submitted before the tenancy starts, because otherwise you can't use Section 21. Other changes that the Deregulation Act brought in for us here in England is the changes to Section 21. It was always called Section 21(4)A or Section 21(1)B. I always get them the wrong way around. It's now called Section 21 Form 6A, and it's a prescribed form. So what that means is you shouldn't change it, you shouldn't make any amendments to it. It is prescribed as it is. And in typical government style, when they first come out, they'd not left no space for name and address of landlords. But it also now comes with time restrictions. So I hope, again, that you all know this, but you cannot serve a Section 21 notice until the first 4 months of the initial tenancy has passed. It is only the initial tenancy, not any future tenancies, no renewals. So the initial tenancy, so the first tenancy. And it does now have a lifespan of 6 months from the date of service. Not 6 months from the date it expires, which some people think. It's 6 months from the date you served it. So effectively, once the notice expires, you have 4 months to make the decision to make an application to court. We had a landlord ask us the other day to serve notice on a tenant ending in June. And I said, well, why are we serving it so early? Because you're putting such restrictions on yourself as to the expiry date of that notice that you're only going to have 4 weeks to make your application to court. Improvement notices, there was something put in called retaliatory eviction, whereby what they've done is basically said, you rogue landlords that just kick tenants out because they want maintenance doing, we're going to stop that. You can't do that anymore, because if there's an improvement notice been issued, you now can't serve Section 21 for 6 months. But again, the questions I get asked around this is a letter from the council an improvement notice? No. You're only restricted from using it when you've been served a formal improvement notice. So don't get the two confused. And just do bear in mind, notice can't end before the end of a fixed term because you can't kick somebody out while they're still in a contract. And it doesn't no longer have to be served within the rental period due date. Back in the day, do you remember we'd all rush to serve it because if we missed it by a couple of days, we've got to serve 3 months. That has now gone, and you can serve notice at any point as long as it doesn't end before the end of the fixed term and the timings have been adhered to here. So if you have tenancies prior to October 2015, there's no requirement legally to serve all of the documentation that we talked about here. But we have made the decision to just do it anyway as best practice, just because, again, it avoids the hassles. The amount of arguments I've had with solicitors, judges, they don't always get it right. That might be their field, but they don't always get it right. We probably do more of lettings than they do because this is our sole job. So just as belt and braces, we always just reserve it anyway. What might be a really good idea, because notices are getting harder and the liability is becoming greater, is to have a process within your company that actually any notice that's served is dual signed. And what I mean by that, so anybody that serves it then has it signed off by a senior staff member, having checked that all of your ducks are in a row. Service served notice must be in line with wording in the tenancy agreement. What do I mean by that is, if your tenancy agreement says that you will serve notices by first class post, that means you can't serve them by email. They will not be deemed served legally in court because the tenancy agreement dictates how you serve them. I wouldn't serve them recorded delivery, and the reason being is because if you do and the tenant doesn't accept it, it's not served. First class post and email is probably the best option for service now. We have both of them in our tenancy agreement. But the key here is that the tenancy agreement holds the email address that they're willing to accept notices served on. And there's a clause within your contract that also states that the tenant is responsible to notify you should that email address change. So if they haven't notified you, that means you can just assume that the address for service is the email address provided. When serving Section 8, take consideration of serving both. So Section 21 and Section 8. It won't always allow you. So for example, if you're in a 12-month tenancy and they're only at month 3 and they're in 2 months arrears, you can't serve Section 21. But if you can, it might be worth considering, because if they then do breathing space on Section 8, you can still pursue on Section 21 because it's not in relation to the debt. So unless the landlord can provide you with absolutely everything that you need to confidently say that everything has been done as it should be, you shouldn't really sign a witness statement to anything other than you can factually confirm. So what I would say to you is, with takeovers, if you can't get absolutely everything that you need, get a waiver signed, first and foremost, that we will not be held responsible for anything that happened prior to the date we took over, and we're only basing any action throughout the duration of this tenancy on the information you provided. And if you sign the witness statement, just be careful that it's true to you.